Right now, a landmark case is working its way through the highest court in the land, and gun owners across all 50 states need to pay attention. It started in Hawaii, where the government told concealed carry permit holders they couldn't bring their legally licensed firearm into a mall, a restaurant, or even onto a beach unless they got written permission first. Critics immediately called it the vampire rule, because just like Dracula, you need an invitation to enter. But here's the thing, in nearly every other state in America, it works the exact opposite way. Now, the Supreme Court, the same court that already shook the nation in 2022 by expanding your right to carry in public, is being asked to go even further. We're talking about a 6-3 conservative supermajority that has signaled loudly that they're skeptical of these kinds of restrictions. Legal experts believe a ruling could come by June 2026, and when it drops, it won't just affect Hawaii. It could dismantle similar laws in California, New York, New Jersey, and Maryland, all at once. This is the biggest Second Amendment showdown in years, and most Americans have no idea it's happening. If you believe in the Constitution, if you own a firearm, or if you just want to know what your rights actually are, smash that like button right now and let's break this down together. So let's back up for a second, because to truly understand what is happening right now at the Supreme Court of the United States and why it matters to every single gun owner, every property owner, and every ordinary American from coast to coast, we need to go back to the summer of 2022, because that is when the ground shifted underneath America's gun laws in a way that nobody, not even legal experts, fully anticipated. That is when the Supreme Court handed down its decision in New York State Rifle and Pistol Association versus Bruin. And if you haven't heard of Bruin, you need to, because almost everything happening in gun law today flows directly from that ruling. For decades leading up to 2022, if you lived in a state like New York, California, New Jersey, or Maryland, getting a permit to carry a concealed firearm in public was nearly impossible. These states used what's called a may issue system. That means the government, usually local law enforcement or a county official, had the discretionary power to decide whether you had a good enough reason to carry a gun outside your home. And in practice, that meant most ordinary law-abiding citizens were told no. Unless you were a politician, a celebrity, or had some very specific and verifiable threat to your life, you simply weren't getting a permit. Critics of that system called it a backdoor ban on public carry, and in 2022, the Supreme Court agreed with them. Writing for the 6-3 conservative majority, Justice Clarence Thomas said clearly and directly that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. That was a landmark statement. The court struck down New York's restrictive may issue permitting scheme, and because so many other states had similar laws, the ripple effects were immediate and enormous. Suddenly, states that had functionally prevented public carry for decades were forced to confront the reality that their laws might no longer be constitutional. And here's what's critical to understand about the Bruin decision. It didn't just strike down one law. It created an entirely new legal test that courts must now use when evaluating any gun restriction in America. That test is the history and tradition test. Under Bruin, if the government wants to restrict your Second Amendment rights, it must show that the restriction is consistent with the nation's historical tradition of firearm regulation. In other words, the government can't just say, "We think this restriction is reasonable and helps public safety." It has to go back through American history, back to the founding era, back to colonial times, and find laws or regulations that are analogous to whatever modern restriction they're trying to defend. If they can't find that historical support, the restriction falls. Simple as that. And this test has sent lower courts into something of a tailspin because applying it is far harder than it sounds. The states push back now. When a Supreme Court decision comes down that significantly expands gun rights, you would think that the affected states would simply comply. But that is not what happened. States like New York, California, New Jersey, Maryland, and Hawaii looked at the Bruin decision and essentially said, "Fine, we'll issue more permits, but we'll make it almost impossible to actually use them." These states went back to their legislatures and passed sweeping new laws that created enormous lists of so-called sensitive places, locations where even a lawful permit holder cannot carry a firearm. We're talking about parks, beaches, public transportation, government buildings, sports arenas, bars and restaurants, libraries, hospitals, and crucially, private property open to the public. That last category is what is now before the Supreme Court. Hawaii, for example, passed a law in 2023 that says if you have a concealed carry permit, which you are now legally entitled to have under Bruin, you still cannot bring that firearm onto any privately owned property that is open to the public unless the property owner has given you explicit express permission to do so. We're not talking about a no-gun sign, we're talking about the reverse. The default is that you cannot carry. You can only carry if the owner specifically says yes, either verbally in writing or by posting a clear sign saying guns are allowed. Legal critics immediately dubbed this the vampire rule, because just like the vampire folklore that inspired Bram Stoker's Dracula, you need an invitation before you can enter. Think about what that means in practical, real-world terms. You wake up in the morning and you want to go through your day as a licensed concealed carry holder. You need to stop at an ATM. You need to pick up groceries. Maybe you're going to meet a friend for lunch at a restaurant. You want to browse a store at the mall. Under Hawaii's law, unless each one of those businesses has proactively posted a sign saying guns are allowed, you legally cannot enter with your firearm. And here's the reality that one of the plaintiff's attorneys pointed out during oral arguments at the Supreme Court: that law effectively bans concealed carry on approximately 96.4% of publicly accessible land in Maui County. Almost the entire usable public landscape of the island becomes a gun-free zone by default. Critics say that's not implementing Bruin. That's erasing it. 3 ordinary people and a coalition. The people challenging this law are not lobbyists. They're not gun industry executives. They are 3 ordinary residents of Maui: Jason Wolford, his wife Allison Wolford, and their neighbor Adam Kasperzicki. They filed suit in June of 2023 along with the Hawaii Firearms Coalition. Their case, known as Wolford versus Lopez, with Ann Lopez being Hawaii's Attorney General, has now made it all the way to the highest court in the land, and their argument is straightforward. Hawaii's law effectively nullifies the right to public carry that Bruin explicitly confirmed. If you cannot carry anywhere you actually go in your daily life, then your right to carry isn't a right at all. It's a mirage. The Wolford plaintiffs have explained in plain terms why this matters to them personally. They say they want to carry for self-defense in places where they feel vulnerable, at isolated beaches, at ATMs late at night, walking to their car after dinner at a restaurant. These are not fringe scenarios. These are the situations that concealed carry is designed for. And yet, because almost no business in Hawaii has proactively put up a guns allowed sign, partly because many business owners fear it would deter customers, these 3 people effectively cannot exercise what the Supreme Court has said is a constitutional right. Their attorney, Alan Beck, has argued passionately that the burden should be on the property owner to say no, not on the gun owner to seek permission at every door. The justices weigh in. On January 20th, 2026, the Supreme Court heard oral arguments in Wolford versus Lopez. And what happened in that courtroom gave gun rights advocates a lot of reason for optimism. The 6-justice conservative majority was openly skeptical of Hawaii's law. Justice Samuel Alito, one of the court's most vocal Second Amendment supporters, said directly to Hawaii's attorney, the high-profile lawyer Neil Katyal, that Hawaii is treating the Second Amendment as a second-class right. Those were his exact words. And in the context of Supreme Court oral arguments, when a justice says something like that directly to the government's lawyer, it is a very telling signal about where that justice's vote is likely to go. Justice Neil Gorsuch had his own pointed line of questioning. Hawaii's legal team had leaned heavily on a Louisiana law from 1865 as a historical precedent for their restriction. They argued it showed a historical tradition of requiring permission to carry on private property, but Justice Gorsuch noted something deeply uncomfortable about that argument. The 1865 Louisiana law was a black code, legislation specifically designed to disarm newly freed Black Americans after the Civil War. He pointedly asked Hawaii's lawyer how a law rooted in racial oppression could serve as a foundation for constitutionally valid firearm regulation today. Hawaii's team struggled to answer that question persuasively, and the moment crystallized a broader problem with the state's entire historical argument. Even the liberal justices offered Hawaii's position only limited support. Justice Ketanji Brown Jackson asked probing questions about whether Hawaii's law was really a Second Amendment restriction or more of a property law clarification. She suggested that after Bruin established a right to carry publicly, the states were trying to define the rules around that right in a reasonable way. But even in her framing, there was acknowledgement that Bruin had fundamentally changed the landscape. The conservative justices pushed back on that interpretation, with Justice Gorsuch suggesting that you cannot use property law as a constitutional workaround to effectively eliminate a fundamental right. The question, as the court's questioning made clear, is where exactly the line is. The broader stakes. Hawaii is not the only state watching this case with white knuckles. California, New York, New Jersey, and Maryland all passed similar laws after Bruin. Laws requiring property owner consent before a permit holder can carry on private property open to the public, and several of those laws are already in legal trouble. The Second Circuit Court of Appeals struck down New York's version of the rule. The Third Circuit Court of Appeals struck down New Jersey's. The Fourth Circuit Court of Appeals struck down Maryland's. But the Ninth Circuit, which covers Hawaii and California, went the other direction and upheld Hawaii's law, creating what lawyers call a circuit split. When federal appeals courts across the country are reaching contradictory conclusions on the same constitutional question, that is precisely when the Supreme Court typically steps in to resolve the conflict, and that is exactly what happened here. What makes the potential ruling in Woolford versus Lopez so powerful is that it won't just affect Hawaii. A decision by the Supreme Court is the law of the land. If the court strikes down Hawaii's vampire rule, it will functionally wipe out every similar law currently on the books in California, New York, New Jersey, and Maryland. Millions of licensed concealed carry holders in those states, who currently exist in a kind of legal limbo thanks to injunctions and appeals, would gain clarity. The default rule in all 50 states would become what it already is in 45 of them. Unless a property owner clearly says no, a licensed carrier is permitted to enter. And then there's the even bigger picture to consider. The Bruin decision already fundamentally restructured the constitutional test for gun laws in America. A ruling in Woolford could further define exactly how far that test extends, not just to public streets, but to the complex, real-world landscape of stores, malls, restaurants, and every other private space where Americans spend their daily lives. Legal analysts across the spectrum agree that Woolford is shaping up to be one of the most consequential Second Amendment rulings since Bruin itself. Some are already calling it Bruin Part 2, the other side of the argument. Now, to be fair, and this is important because this is a genuinely complex constitutional question, Hawaii and its supporters are not arguing in bad faith. Their position has real logic to it, and understanding their argument makes the stakes even clearer. Hawaii's central claim is that the Second Amendment does not give you the right to walk onto someone else's property with a firearm without their consent. Private property rights are among the most fundamental principles in American law. And Hawaii says its law doesn't restrict the right to carry on public streets, sidewalks, or land you own or lease. It simply says that private property is private, and the owner gets to set the rules. Gun safety advocates like Everytown for Gun Safety have supported Hawaii's position, pointing out that research shows a majority of Americans across the political spectrum actually prefer the no-carry default, meaning people generally agree that guns should not be assumed welcome unless the owner says so. Organizations like Giffords Law Center and the Brady Campaign argue that Hawaii's law represents exactly the kind of local democratic choice that the Constitution should allow. They point to the fact that Hawaii has some of the lowest rates of gun violence in the entire country, and they argue that the state's culture and tradition with respect to firearms is entirely its own, separate from the mainland. Hawaii's team even tried to invoke the history of the Hawaiian kingdom itself, noting that King Kamehameha III banned firearms in 1833. That argument drew somewhat incredulous responses from the more conservative justices, with the plaintiff's attorney calling it absurd to suggest that the constitutional rights of American citizens should be governed by the laws of a foreign monarchy. But Hawaii's broader point, that context, culture, and local tradition should matter in constitutional analysis, resonates with many Americans who are uncomfortable with the idea of a one-size-fits-all national gun policy imposed by unelected justices. What happens next? A decision in Woolford versus Lopez is expected by late June 2026. That is the end of the current Supreme Court term. Based on the oral argument, the overwhelming consensus among legal observers is that the conservative majority will rule in favor of the gun owners and strike down Hawaii's vampire rule. The real question is how broadly or narrowly the court writes its opinion. A narrow ruling might only address the specific question before the court, whether the default must be carry permitted unless the owner says otherwise. A broader ruling could lay down sweeping new principles about how the Bruin test applies to carry restrictions across all private spaces, which would have implications for gun laws far beyond the vampire rule question. And there is yet another gun rights case working its way through the system simultaneously, United States versus Himani, which challenges the federal law prohibiting firearm possession by users of controlled substances under the same Bruin history and tradition framework. That case was argued before the court on March 2, 2026, meaning the justices are simultaneously wrestling with multiple fronts of the post-Bruin Second Amendment revolution. The gun rights landscape is shifting faster than at any point in modern American history, and Woolford is at the center of it. For ordinary gun owners in states like California, New York, New Jersey, and Maryland, the potential ruling is deeply personal. These are people who have gone through background checks, completed training, paid fees, and done everything the law requires to obtain a concealed carry permit, and then been told by their state that the permit is essentially useless in almost every practical real-world setting. If the Supreme Court rules as expected, that changes. The permit means what it says. The right to carry for self-defense extends to the mall, the restaurant, the grocery store, to the everyday places where people actually live their lives. The bigger picture. Step back even further and you can see something remarkable happening in American constitutional law. The Second Amendment, for most of the 20th century, was treated by courts as a somewhat dormant right, important in theory, but practically limited to guns in the home. The 2008 Heller decision said you have a right to keep a handgun in your home for self-defense. The 2022 Bruin decision said that right extends to public carry, and now Woolford is poised to say that right extends to the private spaces of everyday life. With each decision, the scope of the Second Amendment has grown more concrete, more enforceable, and more consequential for the millions of Americans who own firearms. Critics of this trajectory argue that the Supreme Court is effectively handcuffing democratically elected state legislatures from responding to the real and deadly problem of gun violence in America. Every day, according to gun safety researchers, nearly 130 people in the United States are killed with guns. They argue that courts should not be tying the hands of elected officials who are trying to respond to that crisis. Supporters of expanded gun rights argue the opposite, that the Constitution means what it says, and that the right to bear arms cannot be regulated into meaninglessness by legislatures hostile to its existence. This tension is not new in American law, but the stakes have never felt higher. What is undeniable is that the Supreme Court, with its current 6-3 conservative supermajority, has shown no signs of pulling back from its expansive interpretation of the Second Amendment. Justice Clarence Thomas, who wrote the Bruin majority opinion, remains one of the most forceful voices on the court for broad gun rights. The Trump administration's Department of Justice filed a brief in Woolford supporting the gun owners, with Attorney General Pam Bondi stating that the government has a substantial interest in the preservation of the right to keep and bear arms, and that Hawaii's law violates the Second Amendment. When the executive branch and the judicial branch are aligned on a constitutional question, the legal outcome rarely surprises anyone. Closing thoughts. So here is where we stand as of today. The Supreme Court of the United States has heard arguments in what may be the most significant Second Amendment case in 4 years. A decision is coming by June 2026. Based on everything we know, the questions asked by the justices, the legal record, the alignment of the current court, the overwhelming expectation is that Hawaii's vampire rule is going to be struck down. And when it is, the law of the land will be clear. A licensed concealed carry holder has the presumptive right to bring their firearm into private businesses open to the public unless the owner specifically says otherwise. That is the rule in 45 states already. It may soon be the rule in all 50. For gun owners in blue states who have felt that their Second Amendment rights have been systematically undermined, despite the clear direction of the Supreme Court, this ruling would be a vindication. For gun safety advocates, it would represent another step in what they see as a dangerous dismantling of reasonable firearm restrictions. And for everyone else, for the business owners, the shoppers, the restaurant goers, the people just living their daily lives, it raises real and immediate questions about what the world around you looks like when the default assumption at the grocery store and the bank and the coffee shop is that the person next to you may be legally armed. This is not a story about politics. This is not a story about whether you love guns or fear them. This is a story about the highest law in the land, about what the Constitution means, and about how the Supreme Court of the United States is deciding, right now in real time, what your rights actually are. The decision in Wolford versus Lopez will matter to every American, whether you own a firearm or not, and we will be here to break it down for you the moment it drops. Stay tuned, stay informed, and make sure you are subscribed so you do not miss it, because this is one of the most important legal stories of 2026, and it is just getting started.